a platform where we try to answer and engage with you, but specifically answer questions regarding problems that you may face regarding child custody and child maintenance. We had many webinars in the past dealing with those specific topics. We feel it important to advise people and to inform people of their rights, and at the same time to empower you so that you can handle your specific child custody and child maintenance issues as easily and as stress-free as possible. Okay, the questions are coming in. Thank you for that. Please pose some more questions. And I see we have somebody from Somerset West. Welcome. Today's theme would be something which I've been thinking about for some time, and I do not really have a word to, a word to specifically not describe it, but to put it under. Basically, the phrase is toughen up. And the reason why I'm saying so is that having thought about the amount of people I have been advising for the last few months, only for the last few months, and how they have been responding to the specific problems regarding child custody and child maintenance, it seems to me that they have to toughen up a bit with respect. And this is a prelude to the conversation. I'm not referring to you. The persons that I'm referring to might not be watching this video. They may be somewhere else, but those are my experiences. And having thought about it, I've come to the conclusion that many cases, especially regarding child custody and child maintenance, are not successful for the client, or they do not receive the required desired outcomes, is solely because they are not toughing up. It's a silly phrase I'm using, and that will be the theme for the next few webinars. You need to toughen up. You need to look past the fact that you have been manipulated by the other party with respect to everyone. I'm not referring to any specific gender here. It could be the male that must toughen up. It could be the female that must toughen up. But you need to toughen up, and you need to take control and ownership over your case. Just some random advice to you. Because if you do not do that, you will have to compare yourself to someone that has toughened up, and who will get a better result? The party that is very anxious about his case, that does not want to proceed in fighting for his or her rights because he or she may believe that he or she may be successful. He or she does not want to proceed with his or her case and fight for his or her rights because they are afraid of the other party. They have been victims of domestic violence, gender-based violence throughout their relationship. Toughen up. It's easy for me to say, I know, but you need to do that. So that's just a buzzword for you to hold at the back of your mind when dealing with your matters. And I'll try to think of a theme, or maybe have a webinar specifically to deal with that. The same with me as a legal practitioner. I'm luckily for me, I have many years of experience going for 2 decades on child custody and family law and other legal matters. But if my attitude was, when I represent a client and I know there's a more senior advocate or an attorney, or there may be a senior judge who, in front of whom I'm appearing, who is giving me a hard time, I have 2 options. I can either fold. I can tell my client, I'm not put out for this case. I can walk away, let someone else do the case. Or I can toughen up as an advocate, take the punches, give the punches, and give the best I can for my specific client. And that is what you must do. So today's theme, and for the next few webinars, will be toughen up and fight for your rights. We have someone from Cape Town as well. Welcome. Thank you for that. Let's deal with the first question. I was given an order by the court for maintenance. Father didn't appear, an attorney agreed on his behalf. He now refuses to accept and sign the order. What do I do? Now, it's a difficult thing because an order is an order, full stop. And the moment a party, has knowledge of the order, he or she is obliged to adhere to it. The difficult thing what I mean is, it's difficult because the other party is now refusing to accept responsibility in terms of this order, although his or her attorney has agreed to the client. Then you have to follow the maintenance laws. The maintenance laws specifically stipulate that if a party is not adhering to a maintenance order, it is a criminal offense, and you can have the person, prosecuted for that. And you can go to prison for up to 3 years. Therefore, my advice to the specific commenter is go to the maintenance court, lay a complaint. If the person is working for a boss, you can apply for a garnish order. If the person has certain assets, depending upon the amount, you can have those specific assets attached. So, for example, if the person owes you 100,000 Rand and does not want to pay, it makes more sense to go to the maintenance court and ask for an order to attach his or her car or house, whatever the case may be. I hope that answers that. If you want to add to the comment, feel free to do so. I see the next comment says the following: agree. You have to drive this whole process and be in charge. And I think that goes with the whole issue concerning toughen up. If you do not take ownership of your case, the same way if you're studying for an exam, if you're studying for a degree, a qualification, a diploma, it is up to you to toughen up. You do not understand the work. The work is hard. The lecturer is giving you a hard time. You cannot find the specific relevant material online or when going to the university or to the college, wherever the case may be. You need to toughen up, and start fighting. The same way if you want to lose weight. At the first sign of defeat, what do? You go to the restaurant, you buy food. No, toughen up and lose those pounds. The comment of early on added something else. It says the following: easy to say when you are dealing with someone who refuses to abide to the law and the maintenance officers let them get away with their behavior. Been dealing with this issue for 2 years, and now that I thought the matter was over, the father pulls a tactic and now refuses to sign documents. How much tougher do I get? I cannot take it any further. It's very unfortunate where the maintenance courts and the maintenance systems, how can I say, disappoints you. And it shouldn't be the case. I do not know how to respond to that specific question. It's clearly you had a difficult situation where the situation failed you, but I think there are more resources available. It doesn't end there. If he doesn't want to sign, the law doesn't say you must sign. So if an order gets served upon you, you must not, the law doesn't say that the person must sign acceptance therefore. There is no law that says that. The same way, if someone issues a summons against you and you refuse to sign the summons, all that the sheriff will have to do is say, I attempted to serve it upon him, he did not want to receive a service, and I placed it on his door. I put it somewhere so that he can see it. That is it. So the same applies to the maintenance order. You do not have to sign for it. The sheriff will make sure that he gets it. Tell him, sir, you do not want to sign for it, that's fine, but here it is, put it down and walk away. The commenter goes further. And I'm very happy to receive these comments, and feel free to add as much as possible. His attorney is now playing the game and saying that they are waiting on direction from their client. Those are most probably usual attorney tactics, and the attorney knows how to play the game. I would say go to the maintenance court. That makes more sense to me. The maintenance court will have to deal with this matter. Was the maintenance court being conned? Has attorney really had the necessary authority to sign that agreement? Lay a complaint against this attorney if you need to be. If he says, no, I did not have the necessary consent, so you wasted your time, the maintenance court's time, the child's time, and lay a complaint at the Legal Practice Council. The old term was the Law Society. Do that, but go to the maintenance court and try to resolve this matter. And I think the law, yes. I'm just finding out where are the comments coming from, connecting it to the relevant client. Okay, I have a new comment over here. My son's father was ordered by court to pay maintenance arrears, which he only paid 3,000 Rand with 600 Rand outstanding. Just after he got paid, he was dismissed from work due to drugs. He was told to come back when he is drug free. What will the court do? If somebody is unemployed and the person owes you money, arrear maintenance money, that arrear maintenance money stays, it remains. It doesn't go away. Obviously, I would advise you to go to the court, and if the person has assets, those specific assets must be sold. But it seems to me that specific person does not have any of those specific assets. So the real amount remains. And if the person is not paying any maintenance, despite him being unemployed, and he never made an application to the maintenance court to have the maintenance order varied or set aside, the arrears are just escalating and climbing. There seems to be nothing much you can do at this present moment because he has been dismissed based upon drug use, and he can only come back to work once he is drug free, and that is most probably when he will start earning an income again. So where the father is concerned, it seems to me that's a bit of a waste of energy. But he may have parents who can afford to pay the maintenance on his behalf, and you may want to inquire into that as well. So my advice to you is go to the maintenance court, explain to them the situation. They might be able to assist you in obtaining that specific money. The employer might owe you money. There might be something which you can do with regard to the employer. There might be other assets applicable that you can attach and make use of. But I would say go to the maintenance court and they will be able to assist you and advise you better on the specific issue. Let me connect the commenters. Okay, we have another comment. Father has played his normal game. The father has played his normal game, has now become unemployed in order not to pay his maintenance. So now it is going back to court for review. He has sold all assets to avoid paying maintenance. Do I fight the grandparents now? If the father doesn't have any income and is unable to maintain the minor child, and those are legitimate reasons, then I would say go to the grandparents. That's the long and short of that. I cannot explain it any further because the child needs to eat and the father is not willing to do his part. The maintenance court obviously have to be reasonable. They'll have to determine, is it fair to go to the grandparents at a specific point. But however, if money cannot be taken from the father and the child needs to eat, the child needs clothing, obviously the maintenance court would be the proper forum to approach the grandparents on your behalf. Here we have another question. It goes as follows. Have been fighting my case for 2 years in the criminal court without a lawyer. The other party have a lawyer and abuse the system and delay. But now the NPA is on the case. If he is found guilty, what will the next step be if he doesn't accept the judgment? Can he appeal again and take it to the higher court? So let me explain quickly how does the maintenance criminal court work. There's no criminal maintenance court. It's not a normal criminal court. If somebody does not adhere to a maintenance order, he or she is committing a criminal offense, and a criminal complaint can be laid at court with the prosecutor. The prosecutor will look at it and he will decide to prosecute you for non-compliance with the maintenance order. You will not have a lawyer, of course not, because you will be a witness. He will have a lawyer to defend him. That's how it works. Same way, if you assault somebody at the criminal courts, the prosecutor will prosecute you, the accused person or the perpetrator. The person who is on the witness stand who has been assaulted, he or she will not have a lawyer. His or her lawyer basically will be the prosecutor, if for lack of a better way of stating it, because he will be the prosecutor's witness. Then they go on, but now the NPA is on the case. So it's possible to delay a criminal maintenance matter. Let's say you appear in court the first time, the party is found guilty, as the questioner poses, and he does not accept the decision of the magistrate, he can appeal it, obviously, and is allowed to take it to the High Court. If you are unhappy with the decision of a magistrate's court, you have full right to appeal. You must explain to the higher court, in this case the High Court, that error, the evidence before it